All right. Well, thanks for joining us today for this legislative review session. As always, there's plenty of bills to talk about, but wanted to check in and just see, I guess today's February 11th, 2025, if anyone's watching the recording. And just wanted to see if anyone on the call currently has any bills that they want to talk about or discuss today. Okay, well, if anything comes up throughout the call, feel free. Petra or Don?
There was a bill that that is talking about I think it's 124 if I remember the number, but it's talking about for school employees that any software they need should be provided by the school district, so that's one. And then there's another one that I've been thinking of following, and it's I think it's 329, House Bill 329, and it's Representative Tyler Clancy from Provo. He's a police officer, and he wants to require that the safety of people, being like in homeless shelters and that kind of stuff, be considered. And it seems like I don't know, it seems to me like he doesn't have, he could use some help with his reasoning, but he's not a law enforcement officer by profession, and these people have to they're kind of responsible for dealing with drug policy, and I kind of wonder if there's a way to there's boy, I hope this jumble is coming out fairly clearly. There's there was the DARE organization years ago, and they're back now, as they're calling it Keeping It Real, and they're basically, instead of just telling children to say no, they're telling them how to say no. They're saying to refuse, and to REAL stands for refuse and explain. I forget what the A is, and the L is to avoid, and then the L is to leave. Okay, and I'm wondering if maybe if I follow these bills, maybe I can figure out a way to make sense of that. Maybe at least I'd like to be able to help people get over drug addictions by going at their pace, which I think is hard to understand. And maybe if with this new thing about explaining to children how to say no, they seem to be getting pretty good reviews on it, and it seems to me like it would be a good start, and hopefully something like this could even be tracked onto another session. So maybe those two bills, I think it's 124 and 329, but so it's about programming for like teachers, and it's about safety in at like shelters and that kind of stuff.
Okay. Yeah, thanks for bringing those up.
Yeah.
Let me, I just need to send a link really quickly. Someone trying to get on. All right, so let's look at these. Yeah, 124. Oh, I should share the screen here. So if you can see this, House Bill 124 is giving employees more privacy in the schools. And it goes through and it says that they can't require that you use technology that you don't like on your personal devices. If they're going to require certain technology that's invasive or that you have issues with, then they need to give you a device to do that on. And this bill, its status is that it passed the House. There was only one person that voted against it, and 5 that were not there to vote. And then it did pass out of the Senate committee, so it's onto the Senate. Chances are pretty high it passes based on what it looks like. So that's one, if you're interested in that. Looks like it's doing well. HB 329, you're talking about the safety requirements for homeless shelters. It's stating that there's a bunch of things going on in this bill. It's a little bit longer, but I think one of the things that you were talking about is here in these lines. And it says to ensure the safety and well-being of homeless shelter residents and staff and the surrounding communities, a homeless shelter shall, so shall's saying they have to, maintain a zero tolerance policy within the premises of the homeless shelter on the use, possession, or distribution of an illegal drug. So I would assume that means that if you bring drugs to the shelter in any way, shape, or form, you get kicked out. I don't know what else a zero tolerance policy would mean. And so that's an interesting question of then, well, what happens to all the people addicted to drugs if there's no shelter for them to go to? And then, in some ways they say, well, it's going to help them get over their drug addiction because they'll have somewhere to stay. But addictions aren't necessarily logical, and I'm not sure that it will have that effect completely. And then they say they have to develop and implement bag check procedures and do regular searches. And so that's to help it ensure that it remains free of illegal drugs and weapons. So essentially, if you're homeless and needing to be at a shelter, you're now subject to random search and seizure of your belongings, is what they're proposing. And then they have to cooperate with law enforcement and let the police come and conduct random checks using trained canine units, which again means you're being searched without any probable cause or a warrant. And then they also have to provide the client's name and identifying information. So anytime that it's necessary to avoid a significant risk to public safety in aid of an ongoing investigation or as required by state or federal law, they have to turn over information about the people there. So I understand they want to be tough on drugs and help people avoid those and create more safety. From my perspective, it'll become quickly known you can't go to the shelter because you're subject to random searches and seizures. And I think we'll see a lot more people out on the streets, not in the shelters. But curious if any of you have a different view on the effect that will have with the homeless. But yeah, drug policy is always difficult. So to your point, Lyman, it's I think it's one to watch. And again, there's a lot here. They're imposing, they want homeless centers to start focusing on a pathway to human dignity, having them start to work in these different areas and things. And so there's some, I think these are some good goals to help people. And I know it's always kind of a perennial issue of how do you best respond to the homeless. But this bill goes through and does quite a bit there. So are there others that people would like to discuss? I know, Jill, you had sent some that we'll get to today to talk about. And we can even start talking about those. Because I do think they are actually of fairly high concern. But any others that people wanted to bring up? Thanks, Lyman, for mentioning those. Okay, let's go to two bills here that are very hard to understand without some legal background, but that are doing quite a bit to change the balance of power in Utah. And we're talking the balance of power between the three branches of government. So these are impacting checks and balances, and I think are ones that are decently concerning. So to give a little bit of context into both of these, most of this stems from when Roe v. Wade was overturned by the Supreme Court. Utah had a trigger law, meaning that the law went into effect with Roe v. Wade being overturned, and it banned abortions in most situations. And that law was quickly sued over, and a judge, Judge Stone, I believe, put an injunction in place and said, you can't enforce this law while we go through and figure out whether Utah law provides, whether the Utah Constitution provides any rights to a pregnant woman, and whether we can ban abortions or not. So since then, that law got put on hold, and the courts have just kind of sat on it. They're not moving. They're not doing much. And it's still sitting. And so abortions are still happening in Utah, and the legislature is pretty upset about it. And then in addition, the legislature passed some of their child protection acts. We talked about one of them last week, where they want to do the age verification for play for the app stores. And they passed previous ones that required that social media companies verify the ages of all users before people can use their social media platform. That law was also put on hold by a judge, and it's sitting there. The courts aren't moving on it much. And it was interesting reading some details about the courts. The Utah Supreme Court is actually one of the slowest and least productive Supreme Courts in the nation. It puts out very few written opinions each year. And so the legislature, in looking at some of these things, are getting a little bit upset and feeling like the courts are playing games and aren't reviewing things as they should and whatnot. So Brammer, I believe last year, he had a bill trying to address some of the speed issues with getting to the abortion decision. He was pretty public about it in the news. And that one passed, but he's taking more direct blow at things right now to really kind of weaken the courts a lot in their ability to review the constitutionality of statutes passed by the government. So this first one, they have something in court called standing. And so it talks about the traditional standing requirement. And standing is a concept that you have to have some connection to the claim you're bringing. So for example, if my neighbor was in a car accident, And I just felt really bad for him. I said, oh, I know they're nervous to put their name on the lawsuit, so I'll just go sue and I'll try and get the money for him. I wouldn't have standing. I don't have any connection to that neighbor. I can't go and seek to bring that lawsuit. My neighbor has to bring in their own name because they were the one injured. It relates to them. And the question of standing is pretty easy in something like a car accident. You know, you had to be in the car type thing, or the parent of a child in the car or something to have standing to come before the court. The question gets a lot more difficult in constitutional claims about if a statute or a law is unconstitutional, who has standing to sue? So as an example, if there's a law that comes down and regulates, this is one example that happened the last few years in America. There was a federal regulation that came down and said, if you're a fisherman off the East Coast, you have to pay for this device that tracks your whereabouts and reports information back to the government and put it in your boat. Ultimately, that was struck down as unconstitutional. But if I, as a non-fisherman, had sued, the courts would have rejected me, saying, this law doesn't even apply to you. And we have all kinds of laws in America that don't apply to me because I'm not engaged in the activity it's regulating. So I wouldn't have standing in that situation. And so in a constitutional case, people often will get upset and say, oh, this law is unconstitutional. I want to sue. And you have to say, well, does it directly regulate you? Are you damaged or hurt by it or whatnot? And so in looking at that, what happened in America was as courts got more and more expensive and lawsuits got more and more expensive, they started to have associations and groups that would form to protect certain rights of people. So you may have a group that forms to protect the ranchers and cattlemen of America, or you may have a group that forms to protect, you know, the fishermen of America or the car mechanics of America or whatever. And they'll take, as members of their association, they'll take car mechanics, if it's car mechanics or fishermen or whatnot, and then they file lawsuits. But some of these have gotten to be fairly broad, where their mission is basically to attack unconstitutional laws, and they push the limits as far as they can. A lot of them don't have members, they just have donors that donate, and they take cases. And so what that has led to is that in the Facebook situation, for example, and also the abortion situation. When I say Facebook situation, I'm meaning the social media companies that are required to do the age ID. So in that situation, the social media company situation, and in the abortion situation, those cases were both brought by associations. So kind of like Planned Parenthood, where there wasn't, it's not as much brought by a pregnant woman that says, hey, I have a constitutional right to an abortion. It's more brought by these groups. They've got money, they've got backing. And even on the social media company side, it was a group that claimed to represent the social media company's interests. So Brammer isn't a fan of this because he feels that it proliferates litigation and makes it so that courts get clogged up. And so he's gone through, and it says requirements for a private right of action. And this is talking specifically about, can an individual citizen sue to try and declare something unconstitutional? And so he comes and says, oh, we found that the standing requirement is important to ensure that a plaintiff or the person bringing the lawsuit has a personal stake in the outcome of the action. And then they go into and actually say, we're making the case that the traditional standing requirement is necessary for the separation of powers because it limits a court's authority to hear only a private right of action where the plaintiff has a personal stake in the outcome. And it says the traditional standing requirement protects the legal rights and interests of the person with the right to bring the private right of action. And then he says, if we allow a plaintiff that doesn't meet this traditional standing requirement to assert a claim for the constitutional rights of a third party, then we're actually, he claims, injuring the constitutional rights of that third party, because then they can't bring the claim on their own behalf. And then he feels that conflicts with statutory and procedural laws. And then he says it also circumvents class action laws that protect the third party from having claims litigated on the third party's behalf without the third party's knowledge or consent. So in class action lawsuit, if you're going to be bound by a class action lawsuit, they have to send notice to you and tell you that you can opt out, or if you don't opt out, you're going to end up being bound by the holding in this case, whatever settlement or whatever comes from it. In a constitutional case, you can file a claim that something's unconstitutional, and you will never get notified if you're, so for example, if you're a fisherman and someone sues to say that a fisherman's law is unconstitutional, you'll never receive notice that you want to opt out of that or have the law apply to you or something. It just happens. And so he's saying all these reasons, and then he says, for anyone that's going to bring a cause of action in this state, they have to meet the traditional standing requirement, not this expanded one the courts have allowed for constitutional actions. And what this means is that these associations and these other groups can't bring it unless they can show that all the members consent. So you have to go through with the association and you have to get consent from the members to bring it on their behalf. And you know, all these different things it talks up here too about bringing the cause of action on behalf of someone else. You have to show there is no way for the third party to bring a private right of action to assert their own constitutional rights. That would basically be they're incapacitated in a hospital. There's no way. And I go, wow, that's a very high bar. So he's purporting to do this to help protect your rights so that no one sues and gets a law struck down as unconstitutional without you having a say in that. Curious what your thoughts are at the outset, if this is to protect people or if you think there's something else to this. Have you ever been upset that someone sued and got a law struck down as unconstitutional? You're going, man, I really wanted that law. To me, it doesn't happen. We're usually very grateful that someone else sues and gets a law struck down. And I have intense concerns about this because one of the only ways for people to afford a lawsuit is to go through an association that combines things together, that brings claims. And to me, this isn't about protecting individuals. This is about making it so that very few laws will be challenged as unconstitutional here in Utah. They're trying to really restrict the types of people that can bring a claim that something is unconstitutional. And when you look at his next bill, which is, so it's 203, SB 203, and then SB 204, his suspensive appeal amendments. He's again doing some things here where he says, basically he goes through and he says, if the, it says, if a trial court of this state grants an injunctive order, meaning there's an injunction saying the government can't enforce this law, and the underlying claim is that the state law is unconstitutional, then he says, the defendant can file a motion and require the plaintiff to show by clear and convincing evidence, basically that the plaintiff's going to prevail on the unconstitutionality. The standard of clear and convincing evidence is very high, and so you have to have a very, very strong case at the outset to get an injunction against a law. So he's saying the law has to be so patently unconstitutional that, okay, the court can strike it down with an injunction. But absent it being patently unconstitutional, if it's questionable and they have to go do research, then they can't issue this injunction. And then he says that the defendant, so if the judge still enters the injunction and says, yeah, this is patently unconstitutional, the defendant, which is the government entity essentially being sued, has the right to a suspensive appeal to ask whether the state law is unconstitutional and whether the injunctive order should remain in effect. And this is the line that's most concerning to me. I don't mind that people have a quick appeal to the Supreme Court. I'm all for the courts moving quicker. Again, Utah Supreme Court's not issuing a lot of decisions. But if a defendant brings a suspensive appeal, meaning an appeal from one of these orders that something's unconstitutional, it says the injunctive order, so this is the order that prohibits the government from enforcing it. It says is suspended until the appeal is resolved, or the government just agrees otherwise. So you got to stop and think about this for a minute. So let's say the age verification laws for social media. If Utah can appeal immediately, so if the judge looks at it and says, yeah, this is probably unconstitutional, Utah, there's some pretty deep concerns, we're going to put this law on hold while we look at it. And the government can just appeal, and immediately that injunction's suspended. The government can now enforce the law, and the companies now have to make all the changes to all their social media accounts. They have to collect everybody's ID. And then by the end, the Utah Supreme Court looks at it and goes, yeah, this is actually pretty unconstitutional. You can't do this. What's just happened? We've just given all our information away because there was no ability for us to go into court and get get some fast help from the courts on saying, whoa, this is pretty unconstitutional. And remember, this is even after a court has found that it's pretty unconstitutional. The government can appeal it and then still enforce that law. And we have this happening right now with the Corporate Transparency Act, which is an act it's a means for the federal government to collect information on the close associations of small business owners. And the law has no limit on the federal government's ability to share that information. And so many groups sued over this. Many associations sued over this. They represented thousands to tens of thousands of businesses. There's no way to get consent from every business because they're just huge associations, but they filed the challenge, and at least 3 courts now have struck it down as unconstitutional. But the injunction against it got kicked up to the U.S. Supreme Court, and the U.S. Supreme Court said, yeah, we don't want there to be an injunction in place while this goes through court. So we want the government enforce this while this plays through court, even after 3 courts have said this is so crazy unconstitutional. You have no right to just collect all this information from these small business owners. And the Supreme Court said, yeah, while it plays out in courts, just let the government enforce it. You can't stop them. We'll figure it all out at the end. But the concern with that is, oh, I've just now given the government everything it wanted. So it can just pass a law, patently unconstitutional, get whatever information it wants from us, come into our homes, collect things. So the government could literally pass a law that says, we want to come into your house and collect all your guns. And you would sue and say this is unconstitutional. And as long as the government appeals it, there's no stopping them from doing it while it plays out in court. Even for a law that's so facially unconstitutional. And so I understand Senator Brammer's frustration with the courts and how slow they move. But to me, the simple solution that maintains checks and balances is simply to say if you're going to enter an injunction against a law, you have to fully resolve it and issue a final opinion within 6 months of the injunction or 3 months of the injunction being issued. Pretty simple solution that doesn't get into, oh, we're just going to let the government enforce everything while this is playing through the courts. I think that one's going to come back to bite us very, very hard if this bill goes through. So this is one that, again, from a check and balance perspective, will greatly weaken the courts. It'll make the courts virtually unable to stop any unconstitutional laws that come down from the state, and the state will just be able to do what it wants until the court has been able to go through the process and hear everything and issue a final ruling on it. But by then, if the government's taken all your guns, or if they've taken all your info, or come into your homes and collected whatever they want, they have it at that point. And many times they only need these laws to be in effect for 3 weeks or 4 weeks or however long they want. And the courts have been the check and balance on that prior to this. And this is directly doing away with it. So on this note, I did just want to throw out a random apocryphal reference that's interesting to me. I know a lot of people talk about Esdras Eagles, and you're welcome to look it up. It's in 2nd Esdras 11 from the Apocrypha. But it talks about this eagle that spreads its wings over the whole earth, and it has 3 heads. And many people interpret this. There's a lot of interpretations out there about it being a certain president, or it being related to a certain ruler, people, and they go through and talk about the feathers and whatnot. But for a very long time, as we look at it, the American system of government's been represented by an eagle with 3 heads. This is not an image of Esdras Eagles or Esdras Eagle. This is an image of just the 3-headed eagle that represents America. And the 3 heads represent the different branches of government and how important they are with checks and balances. In the prophecy of Esdras Eagles, one of the heads suddenly disappears. And then there's 2 heads left. And then the one head goes to war with the other head, or attacks it, and essentially leaves at the end. It kills it, and there's just 1 head left. And once there's just 1 head left, the prophecy says that the eagle stops flying. And I've always looked at this, again, whether or not it's true, we don't know. Again, it's apocryphal, who knows type thing. But the reason I bring it up is because as we watch, there will always be powers working to undermine the checks and balances that exist in our country. Checks and balances, transparency, accountability are so critical to maintaining our government and our American system. If we destroy the courts and just kind of gut them and their ability to check the constitutionality of laws, one of these heads is essentially disappearing. And once that happens, we're in a bad way. Then the courts, and then the legislature can do what it wants. The governor can do what they want, and there's nothing to really push back or stop them. There's a lot of talk right now with Trump's administration. Trump's been sued probably thousands of times since he took office. He's issued a lot of orders. He hasn't had a lot of due regard for the law or the Constitution. There's many things, executive orders he's issued that don't care a lot about those, meaning that the lawsuits, many of them are being held as valid by the courts, and the courts are issuing all kinds of injunctions against the federal government, telling them to continue doing things they're required to do by law and whatnot. And there's a big push right now, a growing chorus of people saying to Trump and his administrations, just ignore the courts. Don't listen to them. They're getting in the way. And it's time we just ignore the courts. And this is something that if you go back to the case of Marbury versus Madison from the beginning of America, in that case, the Supreme Court was faced with a very difficult question. There was a U.S. officer who had been commissioned by John Adams, and he was supposed to get paid and take office. It was a midnight appointment right before John Adams went out of office, but it was a valid act of the president. And then Thomas Jefferson gets in, and Jefferson refuses to honor this person's appointment and refuses to pay him. And so the person sues and says, hey, I was validly appointed. I was validly, entitled to this pay. Jefferson refuses to pay me. And the Supreme Court, back in the very young American days, looked at the situation, and they knew that if they just issued an order compelling Jefferson to pay, that Jefferson wouldn't. And they looked at the law and they said, hey, the law is super clear. New presidents can't just axe these officers. You got to pay them. And Jefferson said, I don't care. And so they knew that Jefferson didn't care. They knew that Jefferson wouldn't really follow what they directed. And they knew that if they issued an order from the Supreme Court that was not followed, that it would essentially undermine and destroy the whole court system. So they went through and they were it was a very clever, politically cunning type decision where they went through and tried to figure out what to do to make it so that the executive branch would respect the authority of the Supreme Court, because the Supreme Court has no enforcement mechanism on its own. It can just issue words on a piece of paper, that's all. And there's a video I've done about that if you want to see more of that. That's on the Believe First website, where it goes into great detail through the issues and how the Supreme Court resolved it. But ultimately, the Supreme Court came down and they were so cunning and wise about how they approached the situation and resolved the issue that basically all of America agreed that they would respect the decisions of the Supreme Court from then on. And the court since then has operated on the basis that its power comes from the respect accorded to its decisions. And that comes directly from Chief Justice John Roberts admits that we have to maintain a certain level of respect. And he's not just talking about the Supreme Court, he's also talking about us for the courts. And so one of the ways that the courts can be destroyed in America is if we start to disrespect them in their role. I can understand from a legislative perspective, if you're a legislative rep, you're trying to do something, the courts put a hold on it, it's frustrating. And I'm not undermining the importance of protecting children or stopping abortions or any of those things. But it is something that I believe strongly we need to approach from the perspective of not undermining the respect that we have for the courts and their role, the important role they have. They've really been what's kept America in place for a very long time, the Constitution in place. Whether we like them or not, with some of the decisions, they have pushed back against the federal and state governments, often the only pushback, for centuries now. And they're coming under intense fire because presidents or legislative reps or governors can't do things as quickly and as efficiently as they want to. And again, I say, if that's the real issue, then just mandate that you do things quickly and efficiently. But we're attacking the courts. We're reducing the ability for people to go to court. We're reducing the ability for larger groups to bring claims on our behalf to help us out with these. And then we're saying the government can enforce its laws while an appeal is pending, even if it was patently unconstitutional. And again, we're seeing that. I see that, and it just kind of makes me sick watching the Supreme Court, the U.S. Supreme Court, after 3 judges have found the Corporate Transparency Act unconstitutional. The Supreme Court says, yeah, let the government enforce it. But I think one reason, to be honest, I think one reason they said that is because they know that the government is getting so frustrated with them stopping things that there's risk of bills like this. And this bill in Utah wouldn't govern the U.S. Supreme Court, but it certainly governs Utah. And so these are items. So thanks, Jill, for bringing these up. But but two bills of kind of deep concern to me. And again, when I think about the Eagle, again, I'm not here saying it for sure is or isn't, but I think it's a great reminder that there is a lot of talk currently about a three-headed eagle. And in this vision, two of the heads get destroyed ultimately, and then the eagle stops flying. And to keep America healthy and well, we have to have checks and balances. There have to be inefficiencies. There have to be some give and take back and forth. And so I'm a huge proponent of continuing to support that. Does anyone have any thoughts or questions on any of that? I know we talked about it for a minute, but I just wanted to explain why it was such a big deal to me. Okay, well, we'll go on to another one that changes things quite a bit. And it could be for better or for worse. And this one's maybe a little bit more lighthearted, but student athlete amendments. We have something that's been happening recently. The Supreme Court kind of opened this up in the last few years, but football players, basketball players, other college sports people used to not be able to be paid anything. They were supposed to be amateurs participating in college and not get paid. And it's produced a really interesting conundrum because universities were making so much money off of the students, these people paying or playing. And so ultimately, the court held you can't constitutionally restrict someone from getting compensated for use of their name, image, or likeness. So it means if I'm a great quarterback and someone wants to run a commercial with me in it, that's playing to my name, image, or likeness. I own that, and I can get compensated for that. So as soon as the courts allowed that, there popped up a very large industry immediately that started to pay athletes for their name, image, and likeness. And they used it to attract different athletes to schools. And so, but the payment wasn't coming directly from the university. The universities were still prohibited from paying athletes directly. So you had all these side people, they call them boosters or, you know, these collectives essentially where they'd pool money together and they'd pay them for things like, you're going to go appear for Big Brother, Big Sisters, and we'll pay you for that. And so they were paying them for use of their name, image, or likeness. But these athletes were making, some of the top athletes are making millions of dollars now in college off of this. So Utah, the landscape's changing quickly, and Utah says, you know what, we got to stay competitive in sports. We want to make it so a university can directly compensate a student for these things, making it so those students start to share in the sports revenues from the entity. And because if we don't, they say these other schools are allowing it. I think there's, I don't know, 30 or so states that have allowed it now. Because they're all expecting a settlement with the NCAA that paves the way for it type thing. But it also goes on to also say that athletes that compete are not employees of the university. And so these were interesting to me to start to look at some of the things going on here. And one of the things to ask is, well, why don't we want them to be employees? And there's a school back east, I think it was a basketball team, they voted that they wanted to unionize. They were getting tired of all the work they were required to do, all the demands on their life, not getting paid. And they were saying, we're not even asking for payment. They said, we just want the school to provide health insurance for us because we get injured while playing and we have to pay for it all and we get no health insurance or compensation associated with it. We're just injured. And there was a big debate. Well, are they employees? Are they not? And suddenly everyone realized a very glaring oversight in the American legal system. We have all these protections in place for employees. Employees are people that work to make an institution a lot of money. or a profit. These athletes have certainly worked to make these institutions a lot of money. And it's fascinating because this gets into the realm of even child labor. We let children work extensively at serious risk to themselves and their own health to earn money for universities, to earn money for high schools, to earn money for private groups. And the child labor laws that were meant to prevent child labor didn't apply in America to anything that entertained us. So you could still employ children to be actors in movies and in plays and in sports. And we could subject these people to harm, and we don't even require that they provide workers' compensation to athletes. So if you're on the job and you get injured, your boss is required to have workers' compensation in place. You get paid for your injury. You get paid for your time away from work for your injury. But if you're an athlete, you don't get any of that. And the theory was, well, athletes choose to do this. But I think that could be said of many jobs. Well, someone chose this job over another job and they accepted the safety risks. And so the schools are up in arms going, oh, we can't have these people be employees because it's so onerous to have employees and we can't employ this many athletes, but they're making us millions upon millions of dollars each year. And states rely on it for funding their schools and whatnot. And so there's just a big to-do in society about what do we do with student athletes. So it's become basically accepted that college athletes are going to become paid, and they're going to become paid directly by the universities. But there's a lot of things that will change with this. There was a reason why they didn't allow college athletes to be paid before. You were supposed to be going to school for school type thing. And now we're turning our schools into kind of these revenue centers, and it's certainly about making money more than it is about school. But it also changes the nature of the competition quite a bit. In American sports, for better or for worse, whether you care about sports or not, will change a lot. But the other thing that will change extensively, I believe, is that when a child has the potential to go to a college and make millions of dollars, there's hundreds of colleges across the nation. We're not talking about, just a couple dozen professional sports teams and a pie in the sky type dream of making it to professional sports. We're talking people that can make quite a bit of money playing college sports. That is going to push the pressure on children's sports so much, youth sports. I believe strongly that the tempers, the anger levels, the expectations of parents, the demands on coaches, they're going to skyrocket because people will feel that their kids are getting gypped from making millions of dollars in college. And I believe this is going to have a radical transformation on youth sports programs in the country. And there's already quite a bit of talk of, well, if you can make money in college, what's the difference between high school football and college football? Why can't you make money there too? And so I expect that the more money gets into sports, the more pressure there becomes, the more issues there become. And we see this with gambling as well. We've opened up sports betting across the United States. And I think there was almost $2 billion gambled on the Super Bowl, which is an incredible amount of money for Americans to put into something in one day. But what happens to these athletes is that they start to get blamed for people's loss of money with gambling. And if you're compensating them, you're doing these things, you're putting enormous pressures on these people to go, yeah, there's only $2 billion wagered on this game. Don't lose it. But every time one of the teams is going to lose. And I look at it and go, what are we doing to people? What are we allowing these pressures to become? And I really think there's going to be quite a few fundamental shifts in our society that don't promote kindness, don't promote charity, promote a lot more anger, frustration, and things. And again, they're saying, well, we just have to rush forward. We've got to change it so universities can compensate athletes because everyone else is doing it. And our universities are going to fall behind in competitiveness if we don't, because they won't be able to attract the good players. And I look at it and say, so we're not even talking about what's right or wrong. We're purely talking about what we have to do to keep up with the Joneses. And I get concerned again with laws when we do that. Principles aside, we just say, we need this because everyone else is doing it. And I think there's going to be a lot of negative consequences, to emotional health, mental health, student wellness, child wellness, tons of pressure, a lot more pressure already for kids. And we're saying, but you're not an employee. You don't get any of the protections. We might pay you some money, but you don't get any protections still that traditional employees get, but you're making people a lot of money, including helping the state make a lot of money because they pay less in taxes to support institutions. So interesting thing to me. I don't know if any of you have thoughts or comments on that, or if you're concerned. I know, again, I get concerned. I've coached youth sports, and it's rough as it is, and I think it will get much rougher. But to throw out one that I think is a pretty good one, this is HB 401, and it talks about adult-oriented performance in a public place or in the presence of a minor. And I don't know for sure, but St. George just got in trouble for denying a permit for a drag show parade or something. And a number of the concerns for it are that there's a lot of inappropriate things that can take place at these types of parades or gay pride parades or different things. And it's one thing to, be proud that you're gay. It's another to have inappropriate things in public. And so this does make it a criminal offense to be involved in sexual conduct or nudity in a public place where a child could see you. And I personally am amazed we haven't had this earlier. Maybe it hasn't been an issue because it didn't come up a lot. But this is something that I support quite a bit, is to keep our public environment clean and good, essentially. Let's see. Sorry, this one I'm just going to show because somebody must have ticked off a representative with this one. This is HB 422, and it holds that no city can ban an open house. So if you're going to show off your new or remodeled home, so this isn't even talking about an open house to sell your house. This is just saying you're showing off your new or remodeled home. They're saying the city cannot ban you from having an open house. Can't even regulate an open house. And then they're so serious about this that previously the law said that a city officer wouldn't be liable for punitive damages, which punitive damages are things like when McDonald's spilled coffee on the lady and she burned herself really bad. They looked at it and saw that McDonald's had thousands of complaints filed against it for the temperature of its coffee. So the jury imposed punitive damages and said, we're going to assess millions against you to make you stop doing this. It specifically says if you're a city official and you enforce if you regulate or attempt to regulate or enforce anything against an open house, they can come after you for punitive damages. So there's no defense for punitive damages. So as the city official, so it's going, wow, someone must be really, really frustrated about open houses being regulated. I don't know the genesis for it, but a unique one for sure. But one I want to get to before we stop for the day is the state sovereignty fund that's being proposed. I don't know if any of you have heard Donald Trump talking about this. Donald Trump wants to make a US sovereignty fund, which is essentially putting together a bunch of money, most likely from taxpayers, and then using it to invest and grow business and make a lot of money, and then helping the government run off of the money invested. So this bill proposes to take $139 million from Utah, a lot of which came from taxpayers, put it into a fund that and then invests it, and then at some point in the future, in the year 2075 to 76, the legislature can start to take 50% of the annual earnings from the fund. So they want to put $130 some odd million in, probably some additional funds over time, invest those, have it grow to something huge by 2075. And generally the way they invest it, though, the thing to understand is they're putting it into private business most of the time. And then starting in 50 years, use the earnings from that, up to 50% of the earnings, to fund the state. And I'm curious if any of you have concerns about this type of use of taxpayer dollars to invest in businesses to then produce a return for taxpayers, or if you like the idea. One that I would recommend thinking about going through. Again, I did a presentation, it's also on the YouTube channel, about public-private partnerships and some of the major concerns. And I'm a full-on believer, circling back to some of the stuff we talked about at the start with checks and balances. There is an incredible amount that can go bad here. Quite a bit can go wrong. And it, when you start to tie government money of this sort, business, and there needs to be a lot of very strong checks and balances in place. And we currently have virtually zero checks and balances in place as it relates to public-private partnerships and the government doing things like this. So I think I'm not necessarily opposed to a wise use of taxpayer funds and having some set aside and growing some things in appropriate ways. But I do get deeply concerned about just a wide statement that $139 million we're going to put into an account. We'll start using it in 50 years for taxpayers, but in the meantime, we'll use it for businesses or private groups or whatever it is that we determine to invest with and do things with, and have no checks and balances, no real oversight. And again, I say, if we're going to give the government power to do something, it should be to me, the motto should be checks and balances first, powers second. But if we just give something to them and say, yep, take it, it's yours, and then we try and implement checks and balances after the fact, it's very difficult. And so yeah, but these are some of the bills, check and balance side, that are changing the checks and balances from sports to judiciary to government, public-private partnership type things. So look at these, think through them, and if you have more questions on them or want to talk in more detail, let me know. But I appreciate you guys joining us today. And if you have other bills you want to talk about next week, I think we only have 2 of these left before the session's about done. Then let me know. Otherwise, we'll just go through these as they come up. So thanks for joining.